Welcome to this deep dive. It's specifically designed for you, the learner. Today, we're going to be tackling the, well, sometimes fascinating, sometimes just plain perplexing world of unincorporated
It
associations.
can definitely be both.
Yeah? And look, this deep dive is based on materials made available by the University of London purely for educational purposes. So, this analysis we're doing, strictly educational.
Absolutely. Our aim today is really to unpack how the law deals with gifts, property transfers to these kinds of groups.
And crucially, what happens when they dissolve, when they wind up? We'll be hitting the key cases, the main concepts, trying to really solidify this for you, especially, if you've got exams coming up.
Definitely.
Yeah.
So unincorporated associations, what are we actually talking about here?
Good question. Think about like your local chess club, maybe a residents association, that kind of thing.
Or a university society, perhaps. Groups of people, basically, working together for some shared purpose, often social.
But, and this is the key bit, without the formal legal structure of a company, they don't have what the law calls legal personality.
Which sounds maybe a bit technical, but it causes real practical headaches when it comes to things like owning property.
Exactly. So imagine that chess club wants to buy, I don't know, some fancy new timer clocks. Legally, the Chess Fanatics Club can't actually own those clocks itself, not like a registered company could.
So the puzzle is, how do you give property, money, assets to a group that doesn't technically exist as a single legal entity?
It's not straightforward, is it? You can't just write a check out to the local book group. This is the core problem we're digging into today. How have the courts figured this out?
Well, it's been quite a journey legally. Initially, they looked at a few options, but they all had, well, issues.
Like what?
Well, one idea was just, okay, give the property directly to the individual members. Simple enough, right?
But potentially misses the whole point. If I donate money for, say, new stage lights for the Amateur Dramatic Society, I don't want each member just getting a fiver.
Precisely. It completely undermines the collective purpose. So that wasn't ideal. Another thought was using a purpose trust.
Okay, so holding the property on trust specifically for the aims of the club.
Exactly. But here's a major hurdle in trust law. Generally, trusts for non-charitable purposes, they're not valid.
Yes, the beneficiary principle. And the big case there is Leahy.
That's the one, Leahy v. AG for New South Wales. A really important case. It basically says gifts to non-charitable associations that look like purpose trusts are likely to fail.
Unless, of course, the purpose is actually charitable. That's a whole different area covered elsewhere.
Right. And, if these attempts to give property fail, the law often defaults to a resulting trust.
Meaning the property just bounces back to whoever gave it in the first place.
Yeah, which often isn't what anyone intended. So the courts were really motivated, to find a way to make these gifts work, to uphold the intention, which is usually to benefit the people involved in the group somehow.
Okay, so that desire to validate these gifts, it led to some clever thinking, didn't it? Focusing less on the abstract group and more on the people.
Exactly. The courts started looking really closely at the relationships between the members themselves, their agreements, their rules, essentially their contract with each other.
Even in a really informal group like a knitting circle, there are sort of unwritten rules, understandings about how things work.
Absolutely. And these understandings, these rules, can be viewed as a form of contract. This is where the contract holding theory emerges. It's a fundamental shift.
So instead of seeing it as a gift to a non-existent entity or a dodgy purpose trust,
The gift is seen as going to the individual members, but, and this is absolutely crucial, it's subject to their existing contractual obligations to each other. Obligations to use that property for the association's agreed purposes.
right? So the purpose gets achieved through the contract, not by a purpose trust. It's subtle, but it makes all the difference legally.
It really does. And two really key cases here are Ree Richards' will trust
Repeat true. Yeah.
and Ree Lipinski's will trusts. Ree Richards is really the foundational one for establishing this contract holding approach.
Okay, so this contract holding idea, does it work in just one way or are there variations?
There are basically two main ways it's understood. The first, and probably most common, is the bare trust / contractual mandate model.
Bare trust contractual mandate. Okay, break that down.
So you often have, say, a treasurer or a committee holding the property. Technically, they hold it on a bare trust for all the members.
Meaning the members are the ultimate beneficial owners?
Yes. But the association's rules that contract between the members act as instructions, or a mandate, telling the trustees how they must use that property. for the club's purposes.
So the power ultimately still rests with the members through their rules, and the courts seem willing to sort of look past awkward wording sometimes, like in Lipinski.
Exactly. In Relipinski, the gift said it was for constructing buildings solely for the association. That solely looks a bit like a purpose trust, but the court upheld it under the contract holding theory. They interpreted it as a gift to the members, subject to their contract.
But there's a limit, isn't there? Something about who controls the rules. That came up in Regrant's will trusts.
Yes, absolutely crucial point from Regrant. For this bare trust mandate model to work, the members themselves have to be able to control and change their own rules if some outside body has the final say on the rules.
Then the members don't really have that ultimate control required for the contract holding theory.
Precisely. Regrant highlights that member autonomy over the rules is key.
Okay, so that's one flavor. What's the other approach within the contract holding theory?
The other is sometimes called the purely contractual approach. The idea here is simpler, maybe. All the members are just co-owners of the property, and they're bound by their contract, the rules to use it for the association's purposes.
No trust involved, just co-ownership plus contract.
Right. But you can probably see the practical problem straight away.
Yeah, if you've got, say, 50 members in a sports club, having all 50 as legal co-owners of the bank account or the lease on the clubhouse, that sounds like a nightmare.
It's generally unworkable for anything beyond a very small group. And there's a technical legal issue, too.
Yeah.
How do you actually give property to people subject to a contract they're already part of? It's not a standard way to transfer ownership.
So while it's maybe theoretically possible, it's not very practical.
Not really. There have been academic suggestions about how rules could be drafted to make it work, but you don't really see it relied upon much by the courts. They generally prefer the bare trust contractual mandate model.
And under that model, how do they view incoming gifts, like new donations?
They tend to see them simply as additions to the existing funds held by the trustees.
Mm-hmm.
Like in Reacher, they talked about it being an accretion to the funds.
An accretion to the funds,
Right.
like adding water to a pool that's already there and subject to the existing rules.
Exactly. They don't usually need a specific rule saying, here's how we accept gifts. The existing contractual framework is usually enough.
Right. Now, things get a bit weird with political parties, don't they? There is that Burrell case.
Ah, yes. Conservative and Unionist Central Office v. Burrell. That case took a slightly different path. The court decided political parties weren't quite typical unincorporated associations. They called them political movements.
A political movement. Okay. And how did that affect property?
Well, the court said the contract holding theory didn't really apply. Instead, they viewed a donation as creating an agency relationship. The party treasurer acts as the donor's agent, carrying out the donor's instructions to use the money for the party's aims.
That sounds a bit strained, especially if someone leaves money to a party in their will. How can a dead person have an agent carrying out instructions?
Exactly. It's a construction that doesn't sit very comfortably, particularly with testamentary gifts. It has some quite significant logical flaws, as the source material points out.
Okay, so putting political parties aside as a bit of an outlier, let's shift gear. What happens when the association itself comes to an end? When it dissolves?
This is really important. And crucially, how the property is distributed on dissolution depends entirely on how it was considered to be held in the first place. The two things are completely linked.
And we need to be careful not to fall into the trap of thinking it was held on a non-charitable purpose trust all along, right? Because if it was,
Then the original gift might have been invalid from the start. Reacher was so important in moving the understanding forward on this.
okay, so assuming the gift was validly held, probably via the contract holding theory, what happens on dissolution?
Well, let's tick off the possibilities. If the association's purposes were actually charitable, then any leftover assets are applied CPRES.
Meaning they go to another charity with similar aims, like we saw in cases such as Revernon's Will Trusts or Refinger's Will Trusts?
Correct. Now, in the very rare case where property was held on a specific, valid, non-charitable purpose trust, and these are very limited exceptions, then theoretically the trust should just continue even if the association dissolves. The purpose might still exist.
But that's rare. What about the more common scenarios?
Well, there's the view based on the older, flawed idea of a purpose trust for the association's purposes. If you think the property was held that way, then when the association dissolves, the purpose fails.
Leading to?
A resulting trust. The property goes back to whoever originally contributed it. It sounds logical if you accept the flawed starting point.
The modern view, based on the contract holding theory, gives a different answer.
A much clearer and generally accepted answer, yes. Under the contract holding theory, the members hold the property beneficially, either via the bare trust or as co-owners. Their contract requires them to use it for the association's purposes.
So when the association dissolves,
That contractual obligation simply ends. The reason for the restriction disappears. So the members who are members at the time of dissolution become absolutely entitled to the property. They can divide the assets among themselves.
okay, that makes sense. The contract ends, the restrictions fall away, but you mentioned older cases causing confusion.
Yes, before the contract holding theory really took hold, you get cases like reprinters and transfers and rehoborn arrow components.
What happened there?
In those cases, the courts did end up distributing the assets to the members, but their reasoning was based on that flawed idea of a failed purpose trust, leading to a resulting trust for the contributors, who happened to be the members.
So similar outcome distribution to members, but via a dodgy legal route.
Essentially, yes. The reasoning wouldn't really stand up today because we'd likely say those purpose trusts were invalid from the start. But coincidentally, the result looks similar to the modern contract holding outcome.
And then there's Kunnak v. Edwards. That one seems to stand out.
Kunnak is a tricky one. It involved a society providing pensions for members' widows. When it wound up, there was a surplus. And it didn't go to the members. No. The court said the members had got everything they'd contracted for the potential benefit for their widows. So the surplus went to the Crown as bona vacantia.
Ownerless goods. Why? What was the thinking?
It's hard to pin down precisely, but the most likely explanation is the court implicitly treated it as a kind of private purpose trust for the widows, which had ultimately failed, perhaps combined with a misunderstanding of contract principles. It's widely regarded as anomalous and difficult to reconcile with modern law. You definitely need to know bona vacantia means ownerless property going to the Crown.
Okay, so Kunnak is a bit of a historical oddity. How did the law clarify things and move towards the modern view on dissolution?
Well, you can see the shift really clearly by comparing two cases involving police funds. First, West Sussex Constabulary's Fund.
What happened in West Sussex?
That case, unfortunately, still followed the older, flawed logic, even citing Kunnak. It essentially decided members had no claim on dissolution because the purpose had ended.
But then came Rebucks.
Yes, just a few years later. Rebucks Constabulary Widows and Orphans Fund Friendly Society No. 2. This case is a landmark. The court explicitly rejected the West Sussex reasoning and fully embraced the contract holding theory. Meaning, upon dissolution, the property was held outright by the members who were members at that time. Rebucks really cemented the modern approach.
Now, what about Hanchett-Stanford VAG? Did that add anything?
It dealt with a situation where the association had dwindled down to just one single member.
Can an association even exist with one member?
Well, legally, maybe not as an association, but the question was what happened to the assets? There was a suggestion, an obiter dictum, a non-binding comment in Rebucks, that maybe in such a case the assets would become bona vacantia.
But Hanchett-Stanford rejected that.
Yes. It held firmly that the contract holding principle still applied. The last surviving member became absolutely entitled to all the assets. The contractual restrictions fell away, leaving her as the sole owner. The idea of it going bona vacantia was dismissed. She then chose to give it to charity, but legally it was hers. Remember, obiter dictum is just a judge's side comment, not the core ruling.
Okay. And one more case often mentioned is Gibbons v. Smith. It brings in the Red Denley idea.
That's right. Gibbons v. Smith involved land given to an association. The court used the principle from Red Denley's trust deed.
Remind us of Red Denley.
Red Denley essentially says a trust that looks like it's for a purpose can be valid if it provides direct or indirect benefits to identifiable individuals. It's seen as a trust for those individuals, albeit frowned as a purpose.
So in Gibbons, the land trust was upheld.
Yes, as a trust for the members under the Red Denley principle. And when the association dissolved, the proceeds were divided among the members who were members at a particular point in time. It reinforces that link between Red Denley trusts and trusts for individuals.
Interesting how these different concepts connect. Now, the source material mentions one other potential angle, conditional gifts. Swadling's argument.
Yeah, this is a more theoretical point currently. The argument put forward by Professor Swadling is that a donor might not be creating a trust at all, but making a common law gift subject to a condition.
Like, here's 1,000 pounds on the condition you use it only for buying new chess sets.
Something like that. Not a purpose trust, but a condition attached to the gift itself. If the association then breaches that condition, Say they spend it on a party instead.
The donor might have a claim.
Potentially, yes. The argument is the donor could seek restitution based on unjust enrichment to get the money back because the condition wasn't met.
Has this been tested much in courts?
Not really. It's an interesting academic argument, but there's limited judicial discussion on it so far in this specific context. Something to be aware of, perhaps, but maybe not a central plank yet.
Okay, so that's a lot of ground covered. Let's try and pull it together. For you, the learner, maybe prepping for an exam, what are the absolute must-knows? Where should you focus your study time?
Right. First, fundamentally understand why there's an issue. Unincorporated associations lack legal personality. That's the starting point for everything else.
Got it. Problem one, no legal status.
Then, trace the court's thinking. Know the initial problematic solutions gifts to members personally, invalid purpose trusts, and why they're usually invalid, citing leahy.
Understand the failures before getting to the solution.
Exactly. Then you absolutely must get your head around the contract holding theory. That's the core modern approach. Understand the basic idea, gift to members subject to their contract.
And know the two flavors, bare trust contractual mandate.
Which is the preferred one, and the purely contractual model, and why that one's often impractical.
Key cases for the contract holding theory.
Definitely Reacher, Lipinski, and Grant. Know the facts, know the reasoning, know what each case adds. Reacher establishes it, Lipinski shows flexibility, Grant shows the importance of member control.
Okay. Reacher, Lipinski, Grant. Contract holding theory? Then what about dissolution?
You need to contrast the old approach with the new. Understand the flawed reasoning in older cases like re West Sussex, often leading to resulting trusts, or bona vacantia like in Connacht.
And contrast that with
The modern approach, crystallized in Rebucks, which applies the contract holding theory on dissolution, assets go to the current members because the contractual restrictions end. And no Hanchett-Stanford confirms this, even for a sole surviving member.
So, West Sussex, old flawed, versus Bucks and Hanchett-Stanford, modern contract.
Precisely, and always link it back. The method of holding dictates the outcome on dissolution. If you say it was held via contract holding, the result on dissolution is distribution to members.
Makes sense. Know the initial analysis, know the consequences.
That's the key. If you can explain that journey, the problem, the failed attempts, the development of the contract holding theory, and its consequences for dissolution, citing the key cases, you'll be in very good shape.
Excellent. So, just to summarize the main takeaway. Unincorporated associations can't hold property directly. The law uses the contract holding theory to make sense of gifts, and this generally means assets go to the current members when the group dissolves.
That's a pretty good nutshell version, yeah.
Yeah.
Focus on that contract theory and the key cases illustrating it.
Great. And just a reminder, this deep dive was purely for educational purposes, drawing on materials kindly provided by the University of London. We really appreciate them making these resources available.
Indeed. And maybe one final thought for you to ponder. Given how legal thinking has evolved here, moving from rigid structures to focusing on member agreements,
Yeah.
what might the future hold? Especially with, more fluid online groups, digital associations, cryptocurrencies held by informal groups. How might the law adapt next to manage collective resources in these new forms of association?
That's a really interesting question. Definitely something to think about. We really encourage you to explore this topic further, maybe reread those key cases. Thanks for diving deep with us today.